massive topic that we could go in so many different directions.
We're all going to get older. We're all going to pass away. And again, these documents are essential. A lot of people think that maybe they can outsmart the system too. Oh, mom's moved into long-term care. Can you help me do a deed transferring her house to myself?
Your situation might look a little different.
Tell them no, please, please do not.
Welcome back to the Life Choice Hospice and Palliative Care podcast. Today we are joined by Courtney Podkowa. Courtney, thank you so much for joining us. For those who don't know you or the work that you do, can you share with the audience a little about yourself?
Sure. Well, thank you for having me, Sarah. So I'm an elder law attorney here in Illinois. So what that means is I practice in the area of elder law, which is the area of law that deals with helping seniors or people with disabilities with their special legal needs. So it encompasses a lot of different legal areas, estate planning, special needs planning, navigating the long-term care field, so long-term care planning, government benefits like Medicaid, and then even helping families apply for Medicaid, dealing with long-term care facilities if there's any issues, or even just reviewing contracts. All of those sorts of things that seniors face today. Our law firm, it's a mid-sized law firm practicing primarily in estate planning, estate administration, elder law, real estate, and corporate law. We're called Drost, Kivelhan, McMahon, and O'Connor, or DCAMO for short. And we've got a team of 17 attorneys who can help with all of our local community's legal needs.
I feel like this topic is like we're just touching the tip of the iceberg here, because it's such a massive topic that we could go in so many different directions. I feel like in terms of the work that I've done with different people, we run into a lot of questions. So maybe we can just kind of go through some of these scenarios that I've seen in the field, and I'm sure you deal with them all the time. Maybe we can start with, when should someone consult an elder law attorney, right? What kinds of scenarios do people usually encounter? What's ideal situation? And maybe worst case scenario, because I know you and I have talked about that at points as well.
Sure. Well, there's no time like the present, but I would say for elder law attorneys specifically, the best time to talk with somebody is, when you're getting older and before any health issues arise. We're all going to get older. We're all going to pass away, hopefully not anytime soon, but there's really no time like the present to even just get your estate plan into place. So frequently, I practice in both estate planning and elder law, but typically when families bring their loved ones in, it's because they've noticed something has changed. Mom or dad is not able to physically move around the way they used to. Maybe the holidays have happened and somebody visits and they notice that mom and dad are getting behind on their bills, or things are just kind of consuming them in a way that they didn't used to be. Mm-hmm. So that's always a good kind of trigger if you start noticing something's different, to come and see an elder law attorney. Of course, everybody, again, should have an estate plan, so anybody over the age of 18. But usually the elder law scenarios, those more come into play as you start to age. 65 is the age for seniors, or if you have a family member that has any special concerns or special needs, it's always good to see an elder law attorney to make sure that you've got planning in place to help those family members too. Mm-hmm.
I'm thinking of two things as you're sharing that. One of those kind of being, you mentioned, planning sooner rather than later. And I think an important piece of this is we see the same thing in the hospice world. Families start to come in for the holidays, and their loved one, whoever that is, maybe isn't doing quite as well as they thought they were speaking to them on the phone, right? And so it's kind of this moment of realization, oh my goodness, mom, dad, whoever it is, something's wrong, right? Maybe I don't know exactly what's going wrong, but I know I need to do something. And, I think in some of those cases, as a clinical social worker, I'm thinking you need to get everything in order. as soon as possible. And maybe we can kind of talk through that, right? When you are dealing with a loved one who may be showing signs of cognitive impairment, something like that, and really being in one of those times when time is of the essence, right? We've really got to kind of get things in order, because there will come a time when that's really not possible, or it could be possible, but that's such a messy space to be in. So maybe we can talk a little bit more about some of those complex cases.
Sure. And I appreciate you saying that, because we want to help everybody, but if it does get to the point where it does get to be too messy, or the person no longer has capacity, then we have fewer options. So in that situation, when you notice that somebody is starting to experience some sort of decline, whether it be physical or mental decline, again, seeing an attorney to make sure they've got their planning in place is essential, because there's things we can do depending on, if they have capacity or not, to at least get a plan in place sooner rather than later. So capacity is a big issue when determining whether we can help somebody do their estate planning. In Illinois, you have to be able to have the capacity to understand the documents that you are preparing, reviewing, and signing. So if a person has reached a stage of cognitive decline where they no longer have decision-making ability or testamentary capacity, contractual capacity, then it's too late for them to legally sign these documents. So what we're looking at is instead guardianship, if they want a loved one to be able to step in and help them make those decisions. So when it comes to estate planning, there's a few major documents that any person should have. The biggest ones are power of attorney documents. So there's two types of power of attorney documents. There's a power of attorney for property or financial decisions, and then a power of attorney for healthcare or medical decisions. These are important for anybody over the age of 18, because once you turn 18, nobody else legally has the ability to help you make those types of decisions like they did when you were a child with your parent. So we always recommend that anybody have power of attorney documents in place. And again, these documents are essential because by creating these documents now, while you still have the capacity to do so, and you have the ability to determine who you would want to help you in the role of agent, you're really putting them in place for later when you might lack that capacity or actually need the help. So even if a person today is very healthy, fit, has no need for help and incredibly independent, it's a good idea to get those power of attorney documents in place, because life can change in a minute. You never know what could happen. You could get hit by the ice cream truck going out to get ice cream, or you could prepare, meet an attorney and do these estate planning documents and then not revisit them for another 25 years. But at that point, maybe it's too late to actually sign those. Always planning ahead and having these documents in place in advance is key. By planning in advance, too, we can build provisions into those documents for future scenarios. So again, most people never envision, I'm going to need hospice or I'm going to need long-term care. Almost everybody thinks, I'm just going to die nicely in my bed at night at the nice age of 95, healthy and fine, and I just won't wake up. Unfortunately, that's not the reality for most of us. I wish it was, but a lot of people do have to go through at least some period of long-term care or a hospice situation, or have a hospitalization. So those are the unexpected events that we want to plan ahead for, to make sure that your wishes are followed if that situation arises, and that you've chosen the people that you want to be there to take care of you. So again, the power of attorney for property or finances, that's the legal document that lets another person step in and help you manage your finances. The power of attorney for healthcare or medical decisions, that one lets another person, your agent, step in and help you with medical decisions. Both of those, again, are very important when you're at an end-of-life scenario. If you want somebody to help you with your money, paying bills, that's the power of attorney for property. If you want somebody to communicate with your doctors, help you with medical decisions, that's the power of attorney for healthcare, which I'm sure is who you deal with a lot in your role with a hospice agency.
Thank you for sharing that. It's very descriptive. I see from the social work piece of it that I would just second everything that you said. People don't think about these documents ahead of time. They wait too long. I've seen, worst case scenario is these documents are not on file. I've seen cases where the patient does not have that decision-making capacity, and there is no next of kin. There is no legal next of kin, meaning there is no blood relative. And I think that's such an important differentiation. Seeing cases where, you're talking to the family. Oh, yes, I'm the daughter. Are you the daughter? Are you the stepdaughter? Because those are two
or the niece,
totally different things. Oh no, does the patient have any children? Well, no. Well, actually they do, but we don't consider them. Well, the law considers them children, whether they're estranged or not estranged. And I think those are such important pieces for people to be aware of. There are very, very real consequences to not having these documents on file, especially in those sorts of cases. When you're dealing with clients or patients who may start to show signs of cognitive impairment, you're almost, number one, you're hoping that all the documents are in place. But if they're not, you want to get those in place while it is still possible. And if you're not able to get those in place, then that is really where it gets really messy, I would say, in terms of, are we looking at a neuropsych evaluation to determine that the patient doesn't have decision-making capacity? I've seen typically in those cases, the patient's generally not super receptive to having that assessment done. And then, looking at guardianship it's not a quick fix, right? I mean, this can take time.
Right.
And sometimes you don't have time.
Exactly. So what I like to say is by not creating a plan, you are making a plan. It's just the plan basically of what your state provides as a default under the law. Mm-hmm. So if you don't pre-plan and create power of attorney documents and it's too late for you to sign those when that time comes, mm-hmm. Because you don't have the capacity, then guardianship is the legal avenue mm-hmm. that is pursued in order for another person to help you make those decisions. Guardianship, again, it's great that it exists, but a lot of people don't favor it over having power of attorney documents in place mm-hmm. because it is more expensive. It's a public process. It can be expensive, especially, with guardianship, you need to typically hire an attorney to mm-hmm. represent the person petitioning to become guardian. And it can cause a lot of turmoil in the family if more than one person wants to become guardian, or if a person wants to become guardian and they're determined not to be fit, or if they have some sort of problem that causes them not to legally be able to be guardian in Illinois, that can really result in problems. So again, it exists. It's a backup plan, but ideally a person makes those decisions ahead of time when they have capacity so that the person that they actually want to be helping them is the person that can do it. You mentioned, too, just even determining what happens under a situation where you can't find a loved one. Mm-hmm. So, or if you don't need a guardianship, but maybe there needs to be a medical decision-making maker. That's when the Healthcare Surrogacy Act mm-hmm. comes in. So that is a statute that does actually state who is entitled or who gets preference in making medical decisions for a person where they don't have documents in place, but maybe a guardianship might not be necessary. So it sort of like end-of-life decisions. Mm-hmm. So under the Healthcare Surrogacy Act, the statute does lay out an order of preference or priority for who can make that decision in that role. But let's say you're a widow and you have 5 children mm-hmm. Or 6 children, and half of them say, okay, let's do this, and half of them say the opposite. The physician or medical team taking care of you, they don't know whose wishes to follow, and that can really create a problem. It puts them in a pickle, and I don't envy that position for anybody because, again, if children can't agree or siblings can't agree, then the loved one who's sick, they're they're kind of suffering and stuck at a standstill.
Right. And I think, I mean, I've seen it many times. It's, well, mom told me this. Oh, well, she told me this, right? And everyone has their own reality of the situation, when in fact, some of these conversations could have happened years and years and years ago. Well, she told me she wants everything, right?
Oh,
She
yes.
wants everything done. And it usually does result in a lot of turmoil within the family. Not a great place to be in when you're already dealing with the stress of someone who's very ill. Not a great time to be making those sort of decisions.
Right. It just adds so much more stress onto an already stressful situation, and so much grief too, because not only are you grieving the loss of your loved one, but it's almost like you're grieving the loss of your family in those situations. So the more a person can do ahead of time to make their wishes known, either in writing or to a third party, unbiased, non-family member, the better, because that way, your wishes can hopefully be followed, rather than just playing a game of he said, she said, or mom told me when I was 12 that I could have this dining room set. And it's like, well, that was 70 years ago.
Right.
It's bizarre.
I had a case, a lovely gentleman, a little rough around the edges, but I got to the house and he let me in the door, and to say he was cordial would be putting it nicely.
Oh.
But he said, listen, I have all of my documents in place. You are not to call my daughter unless I tell you to. You're not to do this. You're not to do this. You're not to do this. This is what's important to me. And I said, understood. Not trying to make you do anything that you don't want to do. But he supplied me with all of those documents. He had everything in place. And when the time came where he couldn't make a decision anymore, we were able to go back to those documents and loop in his family in a way that he wanted, right? And I think that was such an important way to respect his wishes and really do things, allowed for him to do things on his own terms, right? Because sometimes, and I think many people would feel this way, maintaining that sense of independence is super important. And by us following what an individual wants is a way to also show them the respect that they deserve. But every person is just very different. I would like to delve a little bit into, I think the topic is like blowing up right now, Medicaid.
Sure.
And I know you and I have talked through different cases at certain points, and I know there's so much that I don't know. And I know you deal a lot with kind of structuring things in a way that will make sense for patients or clients and their families. Can you talk a little bit about that?
Sure. So Medicaid is a government program that will step in and help people cover medical or healthcare costs. So there's different types of Medicaid here in Illinois. You hear a lot in the news right now about Medicaid just for the normal health insurance program for people that are low income. But the Medicaid that I see a lot with the senior community is Medicaid to pay for long-term care costs. So in Illinois, there's essentially three ways to pay for long-term care when you get older. The first way to pay is with long-term care insurance. Not many of us have long-term care insurance, especially because so many people are living so long. It's getting harder and harder to get these insurance policies to pay for your long-term care costs. And by long-term care costs, I'm essentially referring to like your room and board in a long-term care facility. The second way to pay for long-term care is privately, out of your own pocket. So paying with your own savings, your retirement, selling your house and paying those funds to pay for your care costs, which is not ideal to a lot of people either. So many people, everybody that saves their money is typically not doing it with the idea of saying, oh, I'm going to go pay this all to a nursing home someday. Mm-hmm. They're thinking, oh, I'm going to build this legacy and leave it to my kids to take care of them after I'm gone. Mm-hmm. So that leaves a third way to pay for long-term care, and that is Medicaid. Medicaid, again, it's a government program that will step in and pay for somebody's care costs while living in a specific type of long-term care facility, but it doesn't pay for all facilities. That's important to know. So it doesn't cover your typical assisted living facility. It doesn't cover independent living. It's limited to skilled care facilities that accept Medicaid as a form of payment, and also another type of facility in Illinois called a supportive living facility, which is becoming more popular, and that's more like the assisted living level of care. It's just called supportive living, and it takes government funding. So Medicaid, again, it's a great program, but not everybody's entitled to it. It's not an entitlement program. You have to be eligible. Mm-hmm. So that's really where a lot of questions come in is, am I going to be eligible for Medicaid to pay for my long-term care costs? There's a lot of rules and regulations that need to be followed when determining if somebody's eligible, and you can understand why. And if all of us, needed long-term care someday, there's not going to be enough money to pay for everybody's. So you have to be eligible and meet certain levels. The requirements mostly have to do with your assets and income. The assets are really where people kind of have questions on. Mm-hmm. So in order to be eligible for Medicaid to pay for your long-term care, you have to essentially either spend down your money or engage in planning ahead of time to try to preserve some of your funds for long-term care someday. So you hear a lot about the Medicaid spend down or the 5-year look back. Mm-hmm. So in Illinois, when reviewing a person's application for Medicaid, Illinois has the right to go back and review 5 years of that person's financial transactions. So if I were to move to a long-term care facility, I'm a senior, and I want Medicaid to pay for my care, they would have the right to say, okay, let us take a look at your finances and we'll review and see if you're eligible. So they can go back and request to see 5 years of every financial transaction or financial statement that you have. So that includes bank accounts like savings and checking, and it includes your retirement accounts. So if you have an IRA, it includes CDs, it includes car purchases or sales, home purchases or sales. Every single financial transaction you can think of, they're allowed to review. The reason they review it is because they want to make sure that you haven't improperly transferred your assets away, just so that you can be eligible for them to then pay for your care. So in Illinois, a single person is only allowed to have $17,500 left in assets before Medicaid will step in and pay for their care. So you really do have to spend down a lot of funds before they'll step in. A married couple, fortunately, they do let the community spouse, so the person living in the community, have a little bit more money. I'm blanking on the exact number. I think it's around $125,000 in assets that they're allowed to keep. They're also typically allowed to keep the homestead residence.
Yes, I've heard of that.
Yes, and there's personal items and a few other types of assets. But if you have, one spouse who's ill and needs to move to a long-term care facility and the other spouse is healthy, almost all of their assets still have to be spent down essentially before the ill spouse will be able to qualify for Medicaid. So it's a huge concern for a lot of people, especially if you're not anticipating it and you haven't planned ahead. By planning ahead, there are things we can do in advance to build authority into your legal documents, to try to allow your agent to engage in what's called Medicaid planning if that time ever comes. But you can't do that unless you have these documents in place. So that's where elder law attorneys come in too, is when we do estate planning documents, we try to foresee as many hypothetical situations as possible, just knowing that even if somebody comes in and they're age 50 and healthy as a horse, they might not revisit these documents for a number of years, and they might have some sort of health event that they want to try to cover later on. That was a really long explanation.
But it's needed. It's
Okay.
needed. I can't tell you how many times I get these questions, and I'm like, listen, I know this much about it. Not an attorney, so you probably should speak to one. And I think, this piece of the I would say in most cases, it's a difficult and a big decision to have to apply for Medicaid if you are needing to place a loved one in a facility, right? And that doesn't come without if you haven't done things, through someone like yourself, that doesn't come without some real, I would say, consequences. This is not a free thing, right? There are very real implications. Maybe we can talk a little bit about that. I know something that I've heard is, the funds that are paid for, that are paid by Medicaid for someone to live long-term in a facility, that money can be recovered through the sale of the estate.
Sure. So what you're referring to is, so if somebody, has a medical event and maybe they've been living alone in their house.
Yes.
In the community, and all of a sudden they have a fall and they need to move to a long-term care facility, and perhaps most of their assets are tied up in the house. So maybe they don't have a lot of monetary savings, but they have a home that's a house. Right. In that sort of situation, if somebody needs to apply for Medicaid right away to pay for their cost of care, but the house hasn't sold yet, typically, Illinois, as long as they're aware of the situation, they will perhaps approve somebody for Medicaid benefits, but there's the caveat that they will come back later. Sure. And after the person has passed away, perhaps try to recover the benefits that were paid out of the equity of the home. So that would involve putting a lien on their house, or I'm not sure if they put the lien on the house or not anymore. I'd have to look into that one.
Typically, I've heard that they might not, but
they used to. They used to, and I need to look into it a little bit more, but they used to put a lien on it. I don't know if they do that anymore, but they do come looking. So I've had a few situations where I've been helping families administer a loved one's estate after they've died, and the family's excited because, well, they're not excited their loved one died, but they're excited because there's a potential of an inheritance. And they think, okay, there's all this money here that nice Aunt Sally left us. And then all of a sudden we get a notice from Illinois saying, hi, we're here, and we paid $400,000 of care costs for Aunt Sally during her life. We're considered a creditor, and we get paid out of the estate before the heirs. So that can be a really big shock to people. But again, like you mentioned, Illinois, they're paying for the care costs through the Medicaid program. So they're doing so with the understanding of that they will get paid back later if that person does still have assets out there.
And I think that's just such an important thing for people to be aware of. Don't assume that just because you haven't heard something that, it's going to be how we might imagine it in our mind, right? Or just wishful thinking that everything will be fine. I'm so excited. There are amazing benefits to some people who simply do not have the financial resources, who need this payer for long-term care, and I've seen that so many times. But I think if we were to take just even one main lesson is that don't assume, but do seek out a qualified person like yourself to really deep dive into what is your case, what are the different scenarios that might come forward to really put together that plan moving forward.
Sure. And that brings up a good point. So a lot of people think that maybe they can outsmart the system too. So we get a lot of questions about, mom's moved into long-term care. Can you help me do a deed transferring her house to myself so that she'll qualify for Medicaid and we can apply? No, that's not allowed. That's considered a transfer within the last 5 years. And that's something that I don't know if it's on the internet or if it's in a movie or TV show, but so many people think that that's allowable. And I'm sure you get questions too when you're sitting there counseling a family that's going through this healthcare crisis. I'm sure you get questions saying, we should deed mom's house to us now. Or, this is a good timing for us to transfer her IRA to ourselves. Like, no, right. that is the worst possible decision.
Should have been done a while ago.
Right. Well, yeah, you should have thought about it a long time ago, but there's a lot of tricky consequences to doing that. And at the end of the day, it's got to be in the person's best interest, the senior's best interest. So it's not in the senior's best interest, even if they want to to sign a deed transferring their house to their children if it means that they won't qualify for Medicaid to pay for their care. I mean, it's a bad situation.
I will see families all the time who, people, I don't know, one of my hopes is that people will learn more about this before they need to actually use the information, because there's just too many families out there. I understand people are super busy. They've got a lot of other responsibilities, but the number of people that I see who are like, oh, what do you mean? Medicare won't pay for my mom to live in a facility? And they're just absolutely shocked.
That's a great point. Medicare and Medicaid are two totally different government programs.
Yes.
So Medicare is a federal government program that pays for certain hospitalizations, depending on what parts you have too. It can pay for hospice care. Yeah. But Medicare does not pay for long-term care costs. Yes. So it's very different. Medicaid, that does pay for, it covers health insurance again for people that are of low income. And it covers long-term care costs for certain people that are eligible. But if you are one of those people that, again, you're not so wealthy that you don't need some assistance with paying for care, right. Or if you're in the middle class and maybe you've got this wonderful house, but your spouse is living there, it's a tough problem to have.
Absolutely. I think, some people are almost using Medicare and Medicaid interchangeably. Mm-hmm. No, they're very different. Yeah. Medicare, and some people get confused, with, well, my mom, she was living in a facility for, 2 months after her hospitalization. Yes, she was. She was there for rehabilitation, which is very different from long-term custodial care, right? And you have to be meeting goals in order for Medicare or your insurance in general to pay for this. And, that can be a whole nother topic. If you have an Advantage plan, you can be in there for an even shorter period of time because that's dictated by the third-party insurance who's managing it. Lots of different, I think, caveats there. But Medicare and Medicaid are totally, totally different.
Exactly. Yep. And you're right. Typically, if somebody has a hospitalization, they'll go to perhaps a long-term care facility to rehab. They'll be rehabbing for 6 weeks or so. And then if they do decide to stay there, or they have to stay there, even though they don't want to, and Medicare stops paying, then the facility is going to look to the person or their family to pay. It's a tough situation to be in. And the family, like you mentioned, so often they're shocked and they say, oh, but mom has Medicare. She has Medicare. Why isn't that going to pay for her care costs anymore? And it's totally different programs that have very different benefits associated. And it's such a shock to so many people.
Any parting words of wisdom or anything that you'd like to share with those who are listening today?
Sure. I suppose what I'd like to say is if you're ever facing this situation, and since this is a podcast, so it's probably reaching some younger generations and seniors too, of course, but if you're ever in a situation where you notice a loved one is starting to decline, maybe it's physically, maybe it's mentally, maybe it's just, they're not interested in the same things they used to be, and you kind of get your feelers up and you start noticing something's different. That is really the first step to noticing, okay, maybe it's time we review their legal documents or meet with an elder law attorney. Because again, the sooner we can put planning in place, the better you're able to help them, the better we're able to help them, because we don't want it to get to the point where it's too late and certain legal avenues are exhausted and we have to turn to other processes. I wanted to mention too, this is a little bit of a different topic, but estate planning, includes wills and trusts. Those are also important. I think the power of attorney documents are the most important because, again, we're all going to go through some healthcare situation someday where we need help, but a will and a trust are important too because that's a way for a person to express what they want to have happen with their assets after they've passed away or even while they're alive. in the terms of a trust. So by creating a will or a trust, you get to dictate where you want your money to go. A lot of people think, oh, I don't need a will. I've got 2 children. They'll just split everything 50-50. But if you don't leave, well, a will doesn't avoid what's called the probate process or court process. But if you don't leave behind your wishes, Illinois does dictate what is to happen to your assets, and it just might not be what you want or what you think will happen. So something that always surprises people is what happens when a married couple, when one spouse passes away and they have children. So a lot of people assume they're married, okay, if I die, everything will pass automatically to my spouse. They may have to go through probate to get some assets, but everything will just go to them. And under the law, that's actually not the case if you have children. So under Illinois law, if a person passes away and they have both children and a spouse, and they have probate assets, the law actually dictates that half of your assets go to your spouse and the other half go to your descendants, which is really bizarre to me as a person with children that, you know, they would inherit equally to my spouse in that situation. So even, again, wills and trusts, they're essential to have if you want your wishes to be followed. And again, if you want the right person to be in charge of making sure those wishes come true later or following them, it's always good to plan ahead.
And on that note, I think it's also important to revisit these documents, maybe when you've had life-changing events, right? Not revisiting this document since it was, you know, completed 40 years ago, 50 years ago, 60 years ago. Your situation might look a little different. Maybe your relationship has changed dramatically with your children. Maybe your relationship has changed with your spouse. I've seen cases where, you know, the children are no longer involved, but that child, for example, might still be listed as the executor of the will.
Sure.
And now, you know, patient doesn't have decision-making capacity. Well, we're in a very difficult situation at that point. And now, you know, maybe someone has come forward who's very well-intentioned, a neighbor who's been caring for them for the last, 15 years, doing an amazing job. They're not going to receive anything.
Right. Well, and you're exactly right. If you have documents and they're 30 years old, but they still exist, they haven't been revoked, then those do still suffice at the end. So unless you intentionally destroy them in some way that makes it very obvious that you've revoked them, they're still out there. So it could still be that person that you haven't spoken to in 30 years who's making your end-of-life decisions for you or who's accessing your finances. Something we see a lot is people will name their parents in those roles. So maybe a young couple comes in and they're in their 30s and they have young children. And they name each other as primary agents under the powers of attorney or executor under the will. But then they name their parents who are a generation older as backups. And, you know, it's everybody's hope that their children outlive them. So I've seen a lot of scenarios where somebody names their mother or their father as their executor and they've passed away long ago and there's no backup name to them.
Wow.
So that's pretty common too. Or even just something too to when you're talking with families about estate planning is asking them if their beneficiary designations are up to date or match what they want. Not that you have to look at those, but just bringing it up in conversation like, hey, have you double checked your beneficiary designations since so-and-so passed away? We see all the time one spouse will pass and they'll have the surviving spouse named as beneficiary on the accounts, but then there's no successor. So when both of them die, that asset, rather than passing to the children or who they want, it goes through probate. And that can be a really hard pill to swallow for the family when they realize, oh gosh, why didn't I help mom add a new beneficiary designation on there that she wants? It's a tough one.
I just saw one of our patients a couple of weeks ago. His family was visiting him at a facility, and he had his attorney come over. He's like, let's fill out the documents, got to update those. I was like, good for you. But he had everything in place. I mean, this man was totally bedbound, but he knew, and his wife knew, we have to get these documents updated. And so they did. And he actually just recently passed. Like a few weeks later, I'm like, he had everything wrapped up in a neat little package.
That's perfect. So yeah, we make visits to hospitals or homes all the time. As long as that person, again, they have decision making or testamentary capacity, and they're able to understand and sign their documents, we're happy to travel to them, because we don't want people to not have their wishes in place. With hospice, it's difficult though, because, just with hospice, you're doing a lot of palliative care. And once certain pain medications come into place, you have to really worry about, are those impairing their judgment?
Yes.
So again, the sooner the better,
Yes.
Because that's a big concern. And I appreciate people like you who have these conversations with families early on, or, recommend that right away, because if we can help them, we want to. But if they wait too long, that's where we have to pursue other avenues. I was also going to mention too, when it comes to talking to families, I'm sure you do a lot of, living room chats and things like that. If anybody ever comes and says, hey, let's do a deed again, transferring mom's house over to us now. Tell them, no, please do not.
I'll be crawling out of my skin.
Right.
I'll be hearing your voice.
And again, it's not always the children. A lot of times it is the senior, and they're saying, oh my gosh, I would rather die than see my house go to. Everybody thinks their money's going to go to Illinois, but they're terrified of that happening. So they say, oh, wheel me out to the forest preserve before, sending me here.
Yeah.
Like, I don't want that to happen, but there's things we can do. We can do, but we have to go the legal route through the legal avenues. Doing last minute deathbed deeds, maybe it'll work, but there's also really negative tax consequences that could come about from that. So it's always best to meet with a qualified attorney. Again, I practice in elder law, so elder law includes a lot of estate planning, but not every estate planning attorney practices in elder law. So if you're a senior, or if you want to help a senior family member, or if you have a family member who has special needs or a legal disability, it's always a good idea to see an elder law attorney specifically to help with your estate planning, because elder law attorneys typically do build in these extra provisions into the legal documents to try to protect for long-term care or special needs planning scenarios. Whereas your typical estate planning attorney might not think of that, because again, a lot of people just assume I'm going to die in my bed really nicely at 95. No health issues. I'll never have any problems. I'm just going to die like I want to. If you do that, and a typical estate planning boilerplate documents are fine. But if you're like most of us and you have some sort of anything, it's good to have customized documents.
Well, you are a wealth of information. I really appreciate you taking the time to speak with us. And thank you for joining.
Oh, thank you so much, Sarah. It's been great being here. Absolutely. And thank you for all that you do in our community.
Yeah. Thank you for watching.